Hello everyone, I'm Ankit and you're watching StudyIQ IAS English. In our today's video, we'll try to understand why is Article 110 of the Indian Constitution, which deals with matters relating to money bill, in news presently. Now, the reason why we've picked up this topic for our today's discussion is because recently the monsoon session of the Indian Parliament concluded. And in this session, many bills were taken up in order to get them passed from both of the houses, including the Supreme Court Number of Judges Amendment Bill of the year 2026. Now, as per Article 124 of the Indian Constitution, this provision gives the power to Parliament to increase the strength of judges in the Supreme Court, and as a result, the strength of Supreme Court has increased from 34 judges to 38 judges, including the Chief Justice of India. Now, the matter of controversy that has been arised because this bill was taken up in Lok Sabha and it was designated as a money bill. So why has this bill been designated as a money bill? This is the subject of our today's discussion. Now, in order to understand why this bill was designated as a money bill, you have to look at the statement of objects and reasons which is attached with the bill. This statements of objects and reasons clarifies that when you have to create additional post of 4 additional judges in the Supreme Court, there are going to be different kinds of expenditures that need to be made. For example, you have to provide salaries to the judges, you have to provide for pensions of those judges when they retire eventually, then you'll have to undertake expenditure in order to maintain staff, their residences, as well as security. So as a result, the statement of objects and reasons clarifies that the total expenditure which will be charged on Consolidated Fund of India, because you are creating 4 additional judges in the Supreme Court, would amount to more than 14 crore rupees approximately, and as a result, this bill was designated as a money bill. Now, if you look at earlier discussions and judgments given by Supreme Court, for example, Supreme Court reviewed Aadhaar Act of 2016, which was also passed as a money bill. So in that judgment of Supreme Court, a dissenting opinion stated that whenever government takes this route to pass a bill as a money bill, it amounts to fraud on the Indian Constitution. So what is a money bill actually? Why are there controversies relating to the fact that whenever government tries to pass a money bill, it is seen by many as a fraud of the Constitution? This is what we are going to understand in our today's video. And the notes which I will be using, you can also download them by going to a Telegram channel called as ATS Live. And while you're at it, please do not forget to subscribe to the channel also. Okay, so let us start our today's discussion by understanding what is a money bill. And for that, we need to refer to Article 110 of the Indian Constitution. It says that a bill can be deemed to be a money bill. Who deems any bill as a money bill? It is the presiding officer of the Lok Sabha, that is the speaker. So speaker would certify a bill which is introduced in Lok Sabha as a money bill if it fulfills certain condition, which is also mentioned in the Article 110 of the Constitution. Article 110 says whenever government imposes, abolishes, alters or regulates any tax, that bill can be introduced as a money bill. In addition to that, if government regulates its borrowing by saying that any of its borrowing is guaranteed by the Consolidated Fund of India, that bill can also be certified as a money bill. In addition to that, transactions made into and out of Consolidated Fund of India, Contingency Fund of India or Public Account of India can be designated as a money bill. In addition to that, if government declares that any expenditure is charged on Consolidated Fund of India, those kind of expenditures are charged on Consolidated Fund of India, which is made against maintenance, provision of salaries and offices of any constitutional bodies like CAG, like the Supreme Court of India, like pensions of High Court judges. All of those expenditures are charged on Consolidated Fund of India. So for any of that also, you can designate a bill as a money bill. In addition to that, receipt of money on Consolidated Fund of India or Public Account of India or any matter which indirectly relates to all of the provisions I have said, that according to Article 110, these bills can be designated as a money bill. And as I told you, it is the power of the Speaker of Lok Sabha to certify a particular bill as money bill, and according to Article 110 subsection 3, that certification by the Speaker would be considered as final, right? So this is why some bills can be designated as money bill when they fulfill conditions mentioned in Article 110 of the Constitution. Now, typically, whenever you have to pass a bill from the Parliament, the powers of both Lok Sabha and Rajya Sabha are equal, right? So, whenever you pass a bill from Lok Sabha, you have to also pass that similar bill using the same kind of majority from Rajya Sabha before you can send it to President for their assent, so that a bill becomes an act. But with cases of money bill, the powers of Lok Sabha and Rajya Sabha are not equal, they become unequal. Why is that unequal? The reason behind it is Article 109. Article 109 says that if a bill is introduced as money bill in Lok Sabha, then it only requires assent from Lok Sabha. So here, powers of Lok Sabha become superior to that of Rajya Sabha. So suppose you pass a money bill from Lok Sabha, when it goes to Rajya Sabha, the powers of Rajya Sabha with respect to money bill are limited. So when a bill is presented to Rajya Sabha for their assent as far as money bill is concerned, what Rajya Sabha can do, that maximum it can take 14 days, and it can suggest to Lok Sabha that there are certain changes that you can make. But whether that changes have to be accepted or they are rejected, it becomes the sole prerogative of Lok Sabha. So even without any recommendation, if the bill remains in Rajya Sabha, it is deemed to have been given assent by Rajya Sabha, and that is why government has used this option to fast track enactment of bill, because here the Rajya Sabha can't delay passage of money bill beyond 14 days. Right now, many members of the opposition alleged that the government usually takes this route, especially under the circumstances when it does not have enough majority in Rajya Sabha. So government, by designating a money bill, looks to limit the powers of Lok Sabha, and it tries to bypass the power of Rajya Sabha in order to pass a money bill. And according to the opposition, government has done similar thing with Aadhaar Act 2016. It has done the similar thing when it passed amendment to PMLA, Prevention of Money Laundering Act 2002, as well as Foreign Contribution Act 2010 when it brought amendment relating to the same. Now opposition says it is because they have higher numbers in Rajya Sabha, so passing a bill in Rajya Sabha would prove to be difficult for the government. So government has tried to bypass Rajya Sabha by designating a bill as Lok Sabha. So let us understand why has there been challenges with respect to money bill in the Supreme Court of the House. And one of the most notable challenges in this regard has been passage of Aadhaar Act, which was done in 2016 by the Union government. When Aadhaar Act was introduced in the Lok Sabha, it was designated by the Speaker of the House as a money bill, and as a result, the powers of Rajya Sabha with respect to Aadhaar Act also became limited. Now, the petitioners, especially the members of opposition, claimed that the parts of the Aadhaar Act were passed as money bill despite they containing many provisions that were unrelated to the things that are mentioned in Article 110. But Supreme Court in 2018, when it was deciding on this bill, it's upheld the constitutional validity of Aadhaar Act as well as it being passed as a money bill. Now here the opinion of Justice Ashok Bhushan becomes very important. Justice Ashok Bhushan, who also said that this bill is constitutional in nature, explained the fact that the main aim of Aadhaar Act was to provide for subsidies and benefits to beneficiaries. So since it involved expenditures that were made for Consolidated Fund of India, because government provides for any benefits to people from the fund that is Consolidated Fund of India, and as a result, according to Supreme Court, it was valid to be designated as a money bill. But at the same time, Justice Ashok Bhushan said that Speaker's decision of whether a bill is money bill, despite it being called as final by the Article 110 subsection 3 of the Constitution, can be subjected to judicial review. So this is an important change that was suggested by Justice Ashok Bhushan in his majority opinion. But here the minority or the dissenting opinion of then Justice, who later became a Chief Justice of India, Justice D.Y. Chandrachud, became important. Justice D.Y. Chandrachud actually gave a dissenting opinion. That means he felt that this bill was unconstitutional in nature. What was the reason given by him? Let us try to understand this. He said that the passage of Aadhaar Act as a money bill was an abuse to the constitutional process. Why was it an abuse to the constitutional process? Because he highlighted that passing of an ordinary bill as a money bill would limit the role of Rajya Sabha in lawmaking, and it would diminish the status of the upper house of the parliament. So this is the reason why a dissenting opinion of the Aadhaar Act judgment by the Supreme Court highlighted that this amounts to fraud on the Indian constitution. Now, another challenge that was made in the Supreme Court with respect to the use of money bill in passages of ordinary bill was with respect to constitutionality of a Finance Act 2017. Now, Finance Act every year is passed alongside the budget to make changes in order to implement the budget by the government, right? So in Finance Act 2017, it brought changes in number of other different acts, including appellate tribunal and other authorities, qualification, experience and other conditions of service members rule of 2017. Now this Finance Act of 2017 was also passed through by designating it as money bill. So the petitioners who went to Supreme Court, which included Madras Bar Association, All India Lawyers Union, as well as a Congress MP, Mr. Jairam Ramesh, they argued that the Supreme Court should designate Finance Act of 2017 as unconstitutional and void completely, because it dealt with subjects which were unrelated to fiscal subjects relating and given in Article 110. And they also argued that court should have the power to review the decision of speaker, because it is the speaker who ultimately decides whether a bill becomes an ordinary bill or is certified as a money bill, right? Although later on in 2019, when Supreme Court passed its judgment, the Supreme Court quashed some of the reforms introduced in Finance Act, but it did not strike down the entire Finance Act of 2017. But this judgment, like the Aadhaar judgment, was also given by a 5-judge bench. So the Supreme Court observed that we do not have the power, just because we are having an equal amount of benches Aadhaar judgment, so we do not have the power to overrule the Aadhaar judgment. So whether a bill can be designated as a money bill or not, the conditions relating to it can only be decided by a bench consisting of more amount of judges. So as a result, whether a bill can be designated as a money bill or not, what are the factors behind it, would be taken care of in future by a 7-judge bench. And until unless this 7-judge bench gives a judgment, any challenges to the amendment passed through money bill route has been put on hold until the judgment given by 7-judge bench actually comes in question, which is currently pending in the Supreme Court. Right. So in our today's discussion, what did we understand? That there are some considerations given in Article 110 of the Indian Constitution, which highlights whether you can designate an ordinary bill as a money bill. But government increasingly has used this route in order to bypass Rajya Sabha, especially when it does not have adequate number of MPs in Rajya Sabha. Right. So in some cases, justifiably, government has used this route in order to provide for more expenditures from the Consolidated Fund of India, as we have understood in cases of increase the strength of the Supreme Court judges. But in many cases, like in Aadhaar Amendment Act or amendments done to Finance Act, government has used this route in order to fast track the passage of bill, which many petitioners feel that is an unjustified route or is misusing of powers by the government as well as speaker in order to bypass the parliamentary scrutiny, which should be done eventually, right? So if and when the judgment of 7-judge bench comes, we will discuss it even then also. Now, before we move on to the questions that have appeared on this topic in the UPSC exam, let us consider a very important announcement. Now, the matter that I dealt with is a very core part of Indian polity. But in order to qualify UPSC exam, you need to have not just good grasp for polity, but also for economy, history, geography, as well as some other subjects also, including internal security, international relations, ethics, science and technologies, right? So for classes for all of that are provided with StudyIQ in English batches, in bilingual batches and in Hindi batches. To take admissions to English batches, what you can do, just go to our website, select UPSC English option and take course for 27 or 2028. It means that students who are looking to prepare in 2027 and 2028 can register for this course, make the payment and use the multiple benefits that StudyIQ courses offer. To get the best rate possible, just go to our website, and before making the payment, if you use this code ATS Live, you're gonna get maximum discounts on all your courses. Now, before we wind up, there are multiple questions in UPSC exam that have been asked on money bill. One of the questions is from 2013. What will follow if a money bill is substantially amended by the Rajya Sabha? You can solve this question, and also this question which appeared in 2018 regarding money bill. Which one of the following statements is not correct? So here you have to tell me which of the 4 statements are incorrect. Do let me know the correct answers of both these questions in the comment section, and what do you feel about this issue? Also let me know of your opinion. Before we wind up, you can go to our Telegram channel called as ATS Live and download the notes, which I will attach few minutes after this video ends. So this is all from my side. We'll see each other again quite soon. Please have a very good day.